EC silence. My Lords is listing it today and they declared the result last night. My Lord Justice Mishra held so in that case. Please give me relief here also. He will have to show the facts of Mr. Singhvi, which is that you read the law which says charges. A complaint is filed for molestation. The allegation is that I, as the AICC in charge, never took action against this man who did molestation. And he says without charges, he says there is cognizance taken. There is no order of cognizance also. Where is that case before your Lordship? Here is a woman seeking the right to stand in election, not to win it. The RO wins it against her. The RO could not have stood as a candidate himself and won the election better. This matter requires justice to be done. Your Lordship cuts through like a knife through butter to do the concrete justice. There are 100 ways of having a thicket of procedural objections. Every objection your Lordship will presently hear from the other side will be a thicket of procedural. Let me deal with them one by one, 2 minutes. The natural consequence, your Lordship doesn't make me stand for election. Your Lordship sets aside an illegal order which obstructs my standing and therefore renders an election into a non-election by a non-election declaration of result last evening. So if I will participate, I will win or lose as per the democratic process. That is what your Lordship should do. But delay here, technical procedural objection here will defeat the ends of justice. I beseech my Lord, the highest court of the land, to do justice in the matter. So now my rejoinder 3-4 points. Very briefly and pointedly. Number one, I am not arguing the normal rule. Everybody knows the normal rule. I am arguing whether I am right or wrong. Your Lordship will decide whether I come under the exception. Point one. So no point saying he did not read so and so. That's the rule. Every para he is saying is the rule. I am reading the exception. Number two, this is a very important point fell from my Lord Justice Mishra. In the I am strongly opposing any alternate remedy. That's my submission. Your Lordship has to accept or reject it. In the unlikely event that your Lordship finds that I must go in alternate remedy, your Lordship will simply say that since we have held it not maintainable, all his rights in election petition are open. Your Lordship will have to say that.
Therefore, I say that
I am answering that point.
That part of the
so, no, even the Lordship
on merits.
to decide my point about maintainability, your Lordship may or may not make observations about maintainability, but your Lordship will always say at the end that look, he can go in election, that your Lordship doesn't prejudice. That's point number two. Point number three, Form 26, which is cited, cannot possibly override a section. It's elementary. Has the section been repealed? 33A stands as it is. Now suppose I make all forms. Can it override? Can Form 26 stipulate a condition different from section 33A? That's point number three. Point number four. 26, read the form. It says nothing of the sort. It doesn't ask for anything of the sort.
FIR.
Just if your Lordship has got, I'm sorry, it takes time. Just 248 of this book. I'll just give the book. I mean, what is this? Apart, suppose it had said, it can't still violate 33A. But it doesn't say.
FIR, charge sheet.
Yes. My Lord has got, the book is the same, it's 248. What is all this Form 26? Complete red herring,
So kindly read 33A.
Let me read, sir.
33A.
The very section would be read, Millets. The very section could be read.
Read the section properly. Please read 33A.
Yes, my Lord.
In addition to the requirement of the rules.
We have got limited time in rejoinder, please. I am a candidate set up by so and so.
Limited time.
So and so. My contact telephone is so and so. Details of permanent account number are so and so. Now turn to the right hand page. What is para 5? My Lord has got para 5. I'm sorry. My Lord did not read it.
There is no column for any other case except
33.
I declare that there is no pending cases against me.
This in between. You see, you are on VC and we are arguing here. My Lord is looking for 83A. That is 82.
these are 5 columns.
Yeah.
This is all that you have to discuss. FIR, case number, section, and offense.
So let us kindly keep 33A open and now come to Form 26. Kindly just see this absurdity.
So kindly first see 33A.
Rohitki, this is not the way. 33A,
Not the way.
33A is open, Malas.
Kindly read out
whatever it is, your
33A.
Lordship can't change it, I can rewrite it. Now see 26. Form 26 says para 5.
Doesn't read 33A.
Yes.
Pending criminal cases. I declare that there is no pending criminal case against me. Bracket tick this alternative, there is no criminal case. Or the following criminal cases are pending. Now note this, very interesting. What is the following criminal case pending against me? If it is pending. FIR number. What should I write, Malas? I have got a notice which may or may not become an FIR in a private complaint without
You
cognizance.
should have written the number of the case.
Case number with the name of the court, sections of concerned acts, brief description of offence, whether charges have been framed. My Lord must see that. If answer. So what is this chimera of 26? Apart from the fact that it is saying charges have been framed. Now, just 2 or 3 other points. Joshua will just give me that 2 minutes. Punnuswamy come to para 24 and 30 of the succeeding constitution bench of Gill. Come to Gill 24 and 30. my lord's well-established law is, suppose my lord is a constitution bench, and this side is another constitution bench coming up later. If it considers your lordship, then this constitution bench will prevail. Punnuswamy is considered in para 24 and 30. Just see that.
Yes.
So there is no issue. Punnuswamy, the landmark case, they deal with Punnuswamy's para 24, my lord has got.
Yes.
And then C30, the plenary bar of 329 rests on two principles, which is Punnuswamy's principle, and turn to the next page, 8th line, 9th line, after Durga Shankar Mehta, again Punnuswamy is cited.
Yes.
After all this is para 30. Then they give the exception in 34.
Yes.
34 end, which I read to you. I hope I am clear. Now, my lords asked a very important question, that is Justice Mishra's query, that, is there a case in the Supreme Court or the High Court which has said, I am wrongfully rejected, I return the rejection, I set aside the rejection, I make you fight it. The Election Commission, the custodian, did exactly that in the reverse order in Ahmed Patel's case. Give the copy. That's why we went to the Election Commission.
Yes.
And Mr. Naidu's client's conduct with greatest humility and respect is reprehensible. He doesn't decide. He decides not to decide in a time-sensitive case. This is what they did. And we cited this case to the Election Commission. Just see this, Your Lordship. It was a much worse case where they intervened and overturned the RO.
Yes.
They overturned the RO. Just give me 2 minutes on this. Very important. He doesn't discharge his constitutional duty. And today we have given lectures about how Your Lordship will hear an election petition later on by the Election Commission. Now please see, come to the bottom of the first page. This is very important. This is an order of the Election Commission overturning the RO, which is what we went to the Election Commission for on the 10th. 11th, I mentioned it here. In his report submitted by the RO to the Commission, seeking permission to commence the which was received by the Commission at 5:19 p.m. The returning officer mentioned inter alia that during the course of poll, the election agent of the Congress party, sponsored candidate Parmar, submitted 2 written applications for rejection of votes tendered by 2 voters, Bhola Bhai Gohil and Patel. These we said had shown their vote wrongly, which is required under the law. Now, para 3. When the matter was under the Commission's consideration, the delegation so-and-so represented that the RO had improperly rejected. Right? Then next para 4, the Bharatiya Janata Party opposed. Ignore it. Come to 5. Taking into consideration the above complaints and counter complaint, the Commission considered it appropriate to obtain a video recording of the polling process to ascertain the true. Now, these 2 votes had been cast. They had been cast. And we said it should not cast them. They took it out back. According to relevant provisions, the video recording were obtained from the returning officer, transmitted only.
Why are you reading this?
Because the returning officer, if he goes wrong, the Election Commission has the power and should have reversed. We went to them, spent a whole day arguing. They do nothing.
Some 2017 order.
Yes.
I need to answer that, Millets.
2017 order.
This is 2017, my lord. The form
There is
amended in 2018.
precedent. I am saying, Your Lordship, asked me a question.
Some order passed by the Election Commission.
Binding on itself. Its precedent is that it can reverse a RO who goes wrong.
But this is not a case, my lord, of the Supreme Court
By
interfering
relying on one
against the
order of
improper
the
rejection.
Election
We went-
Commission, that be done.
We went to the Election Commission.
Millets, in terms of section 101C,
No, we
Millets, I
spent an hour
cannot.
arguing this. They did not act on this. Just see the last paragraphs. They just see. Give me a minute, brothers.
So therefore,
I cannot done the role of a high court.
therefore 329 is obliterated.
No, I am not. I have already argued that point. We are under the exception. Your Lordship has full power under Goyal and under Panda and under the Ashok Kumar. That's the first point. Now, my submission is, and 53 is cited. It's a mockery. 53 says when there is unopposed election. My Lord noted that. You declare the result. But I cannot do better than to say your Lordship should not allow this injustice to go on. Injustice, wherever it is, it must be struck, fellows. These bars are meant, fellows, for cases where
Petitioner would fall in question the order passed by the returning officer rejecting nomination, returning officer on 9/6/2026, rejecting her nomination for a Rajya Sabha seat in the by-election, in the biennial election for the Rajya Sabha seats of the state of Madhya Pradesh. Full stop. Petitioner being a candidate belonging to Indian National Congress, submitted her nomination. However, the same has been rejected by the impugned order on the ground that the nomination paper filed by petitioner Srimati Meenakshi Natrajan as a candidate in the Madhya Pradesh Rajya Sabha election, in the Form 26 affidavit, she did not disclose the disclose the said court case, comma, thereby filing an incomplete affidavit. Full stop. It is also mentioned that the court has taken cognizance of this complaint filed against the petitioner, and summons have also been issued to her to appear. Therefore, the case is pending before the court, and that the petitioner has filed her written statement in the said before the said magisterial court. Therefore, she has full knowledge about pendency of the case. Full stop. Para. The petitioner, according to the petitioner, comma, after this, the order, impugn order was passed by the returning officer. The petitioner approached the Election Commission of India. However, no orders have been passed by the Election Commission, despite the you have filed it in written form or
Written or we argued and filed a written note, written representation.
where is that?
That's annexed 82.
Despite filing a written representation and arguing in person before the Chief Election Commission,
Before the full commissioner.
before the Election Commission, June. Post of para. Dr. Singhvi, learned senior counsel appearing for the petitioner, would submit at the outset that the bar under Article 329B of the Constitution of India is not attracted for the reason that the petitioner desires completion of the election process in a fair and transparent manner, and the petitioners and the effort of the petitioner and preparing of this petition has no purpose or motive to thwart the election process. Post of. It is also submitted, comma, referring to section 33 capital A of the right that ROPL, Representation of People's Act 1951, that what is required under the statute is of disclosure of any case where a candidate is accused of an offence punishable with imprisonment for 2 years or more in a pending case in which a charge has been framed by the court of competent jurisdiction. Full stop. Since in the case pending against the petitioner, comma, charges are yet to be framed, cognizance is yet to be taken, and charges are yet to be framed, comma, there is no such violation of the provisions contained in section 33 capital A of the Act 1951, and as such the rejection of nomination is ex specie illegal and manifestly arbitrary. Post stop. It is also submitted, comma, referring to the law laid down in Mohinder Singh Gill versus another versus so and so, 1978 1 SCC 405, and Election Commission of India versus Ashok Kumar 2000 volume 8 SCC 216, so 2004 volume 7 SCC 492, that the Constitution does not contemplate a complete bar for entertaining an election related dispute when the relief claimed in the petition is not for obstructing the process of election, but for its smooth completion in the manner known to law under the Representation of People's Act. Full stop. Para. For contra, Sri Damasisatri Naidu, Laureate Senior Counsel appearing for the Election Commission of India, comma, Sri Mukul Rodhi, he is senior. Sri Mukul Rodhi, Laureate Counsel, representing
all the three private respondents.
Representing the private respondents, comma, Sri Damasisatri Naidu, Laureate Counsel, Senior Counsel, representing the Election Commission of India, and Sri Tushar Mehta, Laureate Solicitor General, appearing for the intervener, State of Madhya Pradesh, would vehemently oppose the prayer, not only the prayer made in the writ petition, but its very maintainability. Post of. According to them, comma, we are recording the submission of all three in chorus
in a combined manner.
because they have argued in chorus. According to them, the right to contest election being a statutory right, comma, a petition under Article 32 of the Constitution of India, which is invocable only when fundamental right of a citizen is infringed, comma, is not maintainable. Post stop. It is also submitted that the law is well settled in catena of decisions starting from Ponnuswamy so and so 1952 Supreme Court, followed without any dilution till date, that when nomination paper of a candidate who is a proposed candidate in an assembly election or a parliamentary election is rejected on whatsoever ground, comma, the only remedy for the candidate is to file an election petition, and the writ court either under Article 226 of the, and the High Court under Article 226 of the Constitution of India, or the Supreme Court under Article 32 of the Constitution of India has no jurisdiction to entertain any such dispute. Full stop. Para. Section 31A of the 33A of the ROPA Act 1958-51 is reproduced hereunder for ready reference. Full stop. The requirement of submitting information is provided under Form 26A is provided in a statutory.
It's Rule 4A of the 61 rules, read with Form
Form 26.
Stood under Rule 4A, 4 capital A, the Conduct of Election Rules 1961, full stop. Rule 4A provides that the candidate or his proposer, comma, as the case may be, comma, shall, at the time of delivering to the returning officer the nomination paper under subsection bracket 1 of section 33 of the Act, comma, also deliver to him an affidavit sworn by the candidate before a magistrate of the first class or a notary in Form 26. Full stop. Form 26 prescribes, Form 26 contains different nature of informations which a candidate is required to disclose or reveal in his affidavit. Full stop. Clause 5 of Form 26 provides for the following informations to be submitted by a candidate at the time of filing of his nomination of the affidavit. ये पेज 304B में ये है, ये टेबल करके फिर क्रॉस करके छोड़ देंगे सबमिट विथ to learned counsel representing the respondents, the petitioner was required to submit information to disclose the information about all pending criminal cases, comma, at whatever stage it is pending before any court. It is not required that only such cases will be disclosed wherein cognizance have been taken or charges have been framed. Full stop. It is submitted that any violation of any non-clean disclosure which is otherwise warranted under clause 5 of Form 26, comma, would entail dismissal of the nomination and rejection of the nomination, and the returning officer has not committed any error of law. Full stop. Para. In the matter of Ponnu Swami, this court has held just a paragraph हम बता देंगे वो reproduce करने. Stop. The principles laid down in Ponnu Swami has been followed in all election related by this court in all election related disputes. Whenever an attempt is made to invoke this court or the High Court's jurisdiction, High Court's jurisdiction to interject during the process of conduct of election, and on every occasion, this court has rejected such an attempt, keeping in view the principle contained in Article 329, Clause B of the Constitution of India. First up, if the arguments raised by Dr. Singhvi that in a case of this nature where rejection of nomination is glaring and manifest, this court must step in to cure the defect. Otherwise, the very sanctity of the election process would be affected and cannot be accepted in view of the law laid down in Ponnu Swami. First off, if this court accepts such argument to find out glaring cases which are required to be interfered under Article 32 or 226 of the Constitution of India, and the other set of cases in which the rejection is not so improper prima facie, relegating them to avail the remedy of filing election petition, this court would be reading some principle which is not provided for under Article 329 of the Constitution of India. First up, this court we are afraid, comma, any such interpretation that in some of the matters this court can entertain a petition wherein a candidate's election petition has been, a candidate's nomination paper has been rejected while leaving some others to avail the remedy of election tribunal should not be encouraged. Full stop. Para. In view of the above, we are not inclined to entertain this petition under Article 32 of the Constitution of India, which fails and is hereby dismissed. Full stop. Needless to say, comma, any observation made herein concerning the basis of rejection of petitioner's nomination is only for the purpose of appreciating the facts of the case, and nothing contained in this order shall affect the election petition, or should any such election petition is filed by the petitioner or any other person before the concerned High Court.
माननीय सुप्रीम कोर्ट ने साफ कर दिया कि चुनावी नियमों के तहत चुनाव प्रक्रिया के बीच में कोर्ट का दखल संभव नहीं है। मीनाक्षी नटराजन के पास अब केवल चुनाव खत्म होने के बाद कानूनी याचिका दायर करने का विकल्प है। माननीय अदालत के इस अहम फैसले पर आपकी कीमती राय क्या है? कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।